Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content. And today will be the day I earned that subscription. For today's issue, we are going to be talking about the upcoming Vallow murders in Idaho. This is a case that's been in development for quite some time. Trial is now scheduled for January 2023, but how it got scheduled for January 2023 is the issue that brings us here today, because Miss Vallow had a speedy trial date, and her trial was initially scheduled for October, but the state wanted to try her together with Daybell, but his trial wasn't scheduled till later. So they had a problem. It's like, well, we can't move her date any further because of a speedy trial issue. We can't move his trial any sooner because of counsel reasons and making sure that they're prepared and stuff like that, unfair notice. But we want to also try them together. So how do we satisfy all these concerns at the same time? Well, the way we have apparently satisfied all these concerns at the same time is by getting her trial moved back. So we have moved it from October of this year to January of next year. But then what about that speedy trial thing I mentioned? Okay, so the judge has written an order relating to this, and we're going to cover that and see what's what. But before we do that, I now have a P.O. box. It's been a while since I've had one. The P.O. box is in my About page, and I have received a couple items, and I want to thank members of the chat who have given me stuff. So first, someone sent me the following note. Says, hello, trying to relax and fall asleep can be a nightmare. I come from a long line of insomniacs. Even though I'm an architectural history who writes books, lectures, and produces documentaries and videos, I also own a very popular company. I create all my own formulas based on ancient remedies. I'm sending you a bottle of some stuff. What you might want to do is wind down at night by listening to audio tours at my website, and close your eyes and relax. It works for me and so many others. Take the products for a week and then kindly let me know if it works for you. I'm sure they will. They are the best greens on earth for this. Keep up the good work. And then he includes his contact information. And he included 2 bottles of products, one of which I will show you on screen. So he gave me this thing called Dreamology, nature's way of helping you sleep. So I can't really speak to the quality or effectiveness of this at all, but I'm going to do some more research on it before I take it myself. But either way, I want to say thank you for that kind gift. And then also received another note. This guy had a bit of a trouble sending it to my P.O. box because he kept giving them the right address and FedEx kept screwing it up. So it wound up with a box inside a box inside a box, which was pretty hilarious. Inside all that was just a simple note written on a paper, handwritten, that says, thanks for all your work, Kurt. And then he included this picture. It's a picture of the United States Supreme Court. That's pretty badass. So I will add that to my wall of art. Awesome. And if you would like to send me some stuff, my P.O. box is on my About page. You're welcome to as well. And thank you for those kind gifts. Let's now go to the story for the day, dealing with this extension and whether or not we have a speedy trial issue on this that might create a grounds for appeal in the far, far distant future. So let's go ahead and read that. This is a copy of the order from the judge. A memorandum decision, an order granting state's motion to continue or delay the trial in the great state of Idaho versus Lori Vallow, also known as Lori Vallow Daybell, because this is her speedy trial issue. So as to this particular issue, she stands alone because Daybell does not have the same problems. The state filed its motion to find good cause to continue and prevent improper severance. So that's what they wanted to avoid. They wanted the trials to be charged together. The alternative would be severing them to trial them separately. Requesting the court to find good cause to continue the currently scheduled October 2022 trial. Defendants file a response. Having considered the motion, and they order the following things. Okay, so let's give some background about how we got this far. On May the 25th, 2021, a Fremont County grand jury returned an indictment charging defendant Daybell as a co-conspirator, well, we'll call her Vallow, co-conspirator Vallow with co-conspirator Daybell in the commission of several crimes, including 2 counts of first-degree murder. Before a defendant could be arraigned in district court pursuant to law, this court found the defendant was legally incompetent to stand trial and committed her to care. So yes, she was incompetent to stand trial for a while there, but apparently now she's better. Accordingly, on June the 9th of 2021, the court entered an order staying the case pending continuation for the treatment. On April the 11th of 2022, the defendant was found competent and fit to stand trial. The court lifted the stay of the case and ordered her to appear for arraignment on April the 19th. During arraignment, the court advised defendant of her rights and subsequently scheduled trial for October the 11th of 2022. On May the 2nd, the state filed a motion requesting the court to continue, that is, delay, the trial to January 9th to coincide with the alleged co-conspirator of Daybell's jury trial and in order to avoid the improper severance of the case. So it was scheduled October, but we'd like it sent to January. So we don't have to do this twice. Common facts, common defendants, all the rest of it. On May the 12th, defendant filed a motion stating she did not waive the speedy trial right, and she understood the continuance would provide her defense team additional time to prepare the defense. On May the 19th, the court held the parties in oral argument. So it is not uncommon for defense lawyers to waive speedy trial. For a whole bunch of reasons. Time is usually thought of as an asset by the defense. So it is very, very common for lawyers to waive speedy trial, but here's someone who doesn't want to. Doesn't want to waive their speedy trial. They'd like to put the state to its burden now, perhaps to create problems for the state vis-a-vis trying to try them both together, because they like to do them both at the same time, but they can't move either date. So, like, what do you do? So maybe that's her motivation. But either way, she wants to hold on to her speedy trial right. Okay, let's discuss. What is the relevant legal standard? That's always a good place to start. Criminal defendants are guaranteed the right to a speedy trial under the 6th Amendment to the Constitution, as well as Article 1, Section 13 of Idaho's Constitution, which could be read differently, and of course, Idaho can grant more than the federal government would require if they are so inclined. In Idaho, these constitutional provisions have been supplemented by legislation that sets specific time limits in which a criminal defendant must be brought to trial. Indeed, the operative statute was enacted in 1864, while Idaho was still a territory and was in force and effect at the time of the adoption of our Constitution. It's been in place a little bit now. The current version of the law reads as follows. The court, unless good cause is shown to the contrary, must order prosecution or indictment to be dismissed in the following cases. When a person is held to answer for a public offense, if indictment or information is not found against him, and filed in the court within 6 months from arrest. So, like, the first thing that would cause a case to be dismissed is if there's no formal indictment filed within 6 months. If the defendant whose trial has not been postponed on his application, because of course it is a right of the defendant which can be waived, is not brought to trial within 6 months from the date the indictment is filed. So you have 6 months to file the indictment, and whenever you do that, you have 6 months from that date to actually bring the case to court. A defendant charged with a misdemeanor offense whose trial has not been postponed by their application, because again, they might delay, and again, it is fairly common for defendants to delay, is not brought to trial within 6 months of the date defendant enters a plea of not guilty within the court. So in the case of misdemeanor, because we're not doing the information indictment thing, because it's a misdemeanor, then it has to be brought within 6 months of the date of the plea, and if not, then speedy trial. Thus, under the relevant law, criminal defendants are given additional protection beyond what is required by the constitutions, which is fine, right? Idaho Constitution can go further than the United States Constitution, and an Idaho statute can go further than both of them, and that would be fine. Constitution sets floors, not ceilings. The statute mandates unless the state can demonstrate good cause for delay greater than 6 months, the court must dismiss the case. All right? So that's what the statute says. It says something about good cause. All right. Thus, defendant is afforded both constitutional and statutory protection as they relate. So the court, in doing its analysis here, is going to have to do a couple different things at a couple times, right? It's going to have to ask basically 3 questions simultaneously. Does this violate the statute? Does this violate the Idaho Constitution? Does this violate the U.S. Constitution, right? So, like, if the answer to all those questions is no, then great. If the answer to one of those questions is yes, then not so great for the government, right? So the government has to win them all. So the questions are, does it violate the U.S. Constitution, which is different than does it violate the Idaho Constitution, which is different than does it violate the statute? Okay, so let's start. An inquiry into speedy trial claim necessitates a functional analysis of the right in a particular context. As Justice Powell said, the right of a speedy trial is necessarily relative. It is consistent with delays and dependent upon circumstances. It secures the right to a defendant. It does not preclude the rights of public justice. A fact-specific inquiry is necessary to assess the particular context for any case where a delay has, or is anticipated to, frustrate the right to speedy trial in order to determine whether good cause exists. Whether there's an infringement of the statutory right to speedy trial presents a mixed question of law and fact. The court will defer to lower findings of fact if supported by evidence. Good cause means that there is a substantial reason that rises to the level of a legal excuse for delay. Because there's no fixed rule in determining good cause for delay of the trial, the matter is initially left to discretion of the court under the statute. So the statute says, hey, don't do this unless there's good cause. If there is good cause, then, okay, but that's only as far as the statute goes. But we got to start somewhere, right? So let's start with the statute. Under the statute, whether there's good cause for failures to try the accused within the period the delay is generally not violative of the accused's speedy trial rights. Finally, the state bears the burden to demonstrate good cause for failure to bring the defendant within the 6-month limit. So it is their burden. Fine. Great. Let's continue on. The state has argued that good cause exists in this case to extend the statutory 6-month limitation for trial, urging the court to schedule a trial concurrently with Daybell's trial. The court must ascertain whether doing so is justified by good cause and would not deprive the defendant of statutory and constitutional rights. Right? So we have 3 different things in play. Again, the statute, the Idaho Constitution, and the U.S. Constitution. We have to make sure we got all 3. Thus, the court considers the mixed question of fact and law in determining whether state has demonstrated by substantial and competent evidence the delay is warranted. The grand jury issued their indictment in this case on May the 24th, 2021, and was filed May the 25th, charging the defendant with the commission of several crimes. Thus, the indictment was timely filed. Thereafter, a substantial delay in bringing the defendant to appear for arraignment due to the stay in this case. The court therefore considers whether that delay violated the law, which requires trial within 6 months from the date the information is filed if the trial has not been postponed by application of the defendant. So the defendant didn't ask for it to be delayed. The defendant was declared incompetent, so therefore the defendant can't ask for anything because they're incompetent. So the defendant definitely couldn't ask. So it wasn't their request, so we have to find this good cause requirement. Idaho Code creates an exception where defendant's trial is postponed by their own application, but that's not true here. Defendant's attorney of record filed a request for the court to order defendant to undergo mental health examination. On June the 9th, following an evaluation report of defendant's mental health status, the court entered a finding in this case they're incompetent to stand trial and ordered commitment to the Department of Mental Health for treatment. Accordingly, the court entered the stay in the proceedings pursuant to law. The court determines that due to the required stay of this case, there's substantial evidence that the exception applies, as the delay was before arraignment was through no action of the court or state, but rather as a direct consequence of the determination the defendant was not fit to spit trial. So actually, they're disagreeing with me and saying that actually the defendant did ask for it. So that's an interesting aspect. That the defense is asking for it. But I mean, I'm not sure that's strictly speaking right, but okay. Thus, the period of time Vallow spent committed to custody is told for the purposes of calculating speedy trial as it relates to the arraignment. So they're going to say that she requested the delay, which I'm not sure strictly speaking is correct, but pressing on. So there's a potential issue of appeal. On April the 11th, defendant was found competent and fit to stand trial and was thereafter arraigned. That implicates the timing of the statute, which requires within 6 months of arraignment. Here, that would be October. The state argued good cause exists to extend to coincide with the trial date set in Daybell's case. Defendant, however, has not waived the speedy trial right. So whatever might be true of Daybell and his speedy trial rights, Vallow hasn't waived her speedy trial rights. Accordingly, the court will apply the relevant factors to determine whether there's good cause to delay. The factors test analyze speedy trial pursuant to 4 factors: the length of the delay, the reason for the delay, defendant's assertion of the right, and any prejudice. The Idaho Supreme Court has determined the court should consider the factors, but look beyond these factors in determining if good cause exists under the statute. Which, fair enough, because the statute, again, doesn't necessarily have to conform to the Constitution. It can provide for more. Under careful consideration of the relevant authorities, we believe a thorough analysis for reasons of delay represents the soundest method for determining what constitutes a good cause. We therefore conclude good cause means that there is a substantial reason that rises to the level of legal excuse for the delay. Thus, the court will consider the factors in determining whether the motion should be granted. Okay, so we've got some relevant authority here on some relevant factors, so let's consider them through. The length of delay serves a dual role in the analysis of the right to the speedy trial. First, it is a triggering mechanism. For until there is some delay that is prejudicial, it's unnecessary to inquire. Yeah, the speedy trial right isn't violated if the delay doesn't impinge the right. Second, one of the factors to be considered is the balancing. Here, the length of delay should the court move the trial, is a period of 90 days and 82 days beyond the current deadline. So we're going to move it by 82 days. So that's the length of delay we're talking about in current, which, is still 3 months more. And we had to bring it within 6 months. So that's a 50% increase. So, still. Thus, the length of the delay here serves as a triggering mechanism for further analysis. Given the length of the delay here is 82 days, and in consideration of complexity of this case and seriousness of the charges defendants face, as more fully explained herein, the court determines the length of delay waivers in favor of granting the state's motion. So they think that the 3 months isn't a big deal. I don't know, man. When the statute is giving you 6 months, and then you say, hey, I want an additional 3 months, I'm not sure necessarily the right way to say that is I want an additional 82 days. Maybe better is to say I want an additional 50%. So there again, maybe a basis for some argument down the road. Let's keep reading. The next factors we consider is the reason for the delay. Different weights attached to different reasons. Now, this is true enough, right? Because if it is a reason that is kind of due to no one's fault. So the best reason basically possible for the state would be some sort of external emergency, right? It would be, I don't know, natural disaster probably is pretty good, right? So there's some natural disaster and people are fleeing the jurisdiction and, so we can't have the trial right now because, the natural disaster. That's not really anyone's fault. It's an act of God. The Constitution isn't that dumb. It isn't the state's fault, it isn't the person's fault, no one is at fault. We're doing our absolute best. We're not going to let the act of God be an issue. God can't violate your rights, I guess, because, it's God. So something like that, maybe. But that would be the best possible example, right? Or some sort of other emergency that would. COVID has gone a long way to doing a lot of this, by the way. COVID has done a lot of work along these lines because the courthouses, we're not operating at full capacity. We're not, and a lot of cases were delayed. And COVID went a long way to being an external factor that wasn't strictly speaking anyone's fault and resulted in delays that did not violate speedy trial. So these issues are notable. Let's see if we can hit 96,000 by the end of the stream. That'd be cool. Only need 140 more subscriptions. So if you haven't subscribed already, consider subscribing. Let's see if we can hit that 96,000 before we're done. But COVID response is not an act of God, but COVID is. So there you go. That's like saying hurricane response isn't an act of God or flooding response is an act of God. Yeah, the underlying thing's an act of God. So no. And even if it's not an act of the court system. So, pressing on before I get too weighted down. A deliberate attempt to delay the trial in order to hamper the defense should be weighted heavily against the state. A more neutral reason, such as negligence or overcrowded courts, is weighed less heavily but nevertheless slants against the state, since ultimate responsibility for such circumstances must rest with the state rather than with defendant. Defense cause delays are not weighed against the state, because the state defense asked for it, so we don't care, because it's their right, so if they want to waive it, not our problem. Force majeure, right idea, exactly. The state cites multiple reasons for delay. The relevant statute stay in this case occurred when defense counsel raised concern defendant may be incompetent to stand trial. The resulting extended period of time during restorative treatment, while committed, cannot be overlooked in assessing the delay. As competency was established and the case came forward for arraignment, delay between arraignment and trial day becomes the focus. The period of time the court must scrutinize is the time between October and January to discern good cause. The primary rationale argued by the state to move defendant's trial date beyond 6 months is to prevent improper severance. Defendant and Daybell were named together in a single charging document, the indictment. The court has ruled that they are and continue to be properly joined. They're implicated in the same crimes, so common facts, sure. Common law, common to both parties. A motion to sever filed in the Daybell case was denied. Defendant's defense team was only recently fully assembled under relevant law, and counsels indicated they need time to prepare defense. The indictment charges defendant and Daybell with the most serious of crimes. They are alleged to co-conspire to commit murder, and the state has filed notice of intent to seek death penalty in both cases. In addition, there are allegations of conspiracy to commit multiple financial crimes. Also, incidentally, and we will get to this in some later video, I'm sure, but not only Idaho wants a piece of them, because they're currently under indictment for murder in Arizona as well. Also, New Mexico seems to be looking into them. So not all is going well over here in the Daybell Vallow camps. Pressing on. These conspiracy allegations were a basis of the court's decision to deny the motion for severance. The court has been advised throughout the proceedings by counsel for both defendants that an extraordinary volume of discovery has been produced. I believe it. Defendant's attorney have expressed concern in regard to having adequate time to prepare for trial, although they've no way argued against their client's assertion of speedy trial. So, like, yeah, you can have, if you want speedy trial, that's fine. But then, of course, defendant only gets that much time, right? You have a right to a speedy trial. If you need more time, then you're allowed to ask for more time, but then you can also ask for speedy trial. So, yes, this is one of the reasons that defense typically, well, often asks for more time, especially in a case like this with the death penalty and stuff. You might need more than the 6 months or even the year to prepare. So, you know, all that good stuff. All that good stuff. For reasons more subtly set forth in the court's memorandum decision denying the motion to sever, the court concluded that the two defendants will be tried together, which, you know, makes total logical sense. They're implicated to each other, co-conspirators, blah, blah, blah. The state's argument that improper severance might occur if the defendant proceeds in October is well-founded. In order to preserve a single trial, the court would be required to advance Daybell's case to October. That would be one thing we could do, but, of course, that would deprive Daybell of time to prepare, so that produces problems in his case. Right? He's already been scheduled for January. His attorney is banking on that time. If we move his case up, then his attorney no longer has time, so we're now prejudicing him. So, like, well, we got to prejudice her or prejudice him, and that's a problem. Given the directive, the court considers whether there's substantial and competent evidence rising to the level of a legal excuse for delay. All the factors weigh in heavy of such a finding when considered the reasons. Okay. Whether defendant has asserted the right to speedy trial, defendant has unequivocally asserted it. Prejudice to defendant. Prejudice to the accused caused by trial delay is assessed in light of interest to the defendant, because it's their rights. Those interests include to prevent oppressive pretrial incarceration, to minimize anxiety and concern of the accused, and to limit the possibility the defense will be impaired. Infringement on the third interest is most serious in form of prejudice because the inability of the defendant to adequately prepare his or her case skews the fairness of the entire system. The nature and extent of prejudice arising out of delay in bringing criminal action to trial is the most important factor. Here, a 90-day delay in proceeding to trial does expand the incarceration. That factor weighs against finding good cause because she's continuing to serve time. The second factor to minimize, this also incidentally, like why a lot of people remain in jail, like pending trials, is because a lot of them waive speedy trial. So like, yeah, if you don't waive speedy trial though, like, you know, they can only hold you in jail so long. So these are the trade-offs that you make. The second factor to minimize anxiety and concern has not been argued by defendant. To the contrary, her counsel, while acknowledging the mental state is fragile and complex, yeah, you think, states since she's been able to cogently and rationally cooperate with the participation defense, the factor is neutral. Okay. The third factor, to limit impairment of defense, weighs in favor of finding good cause. Defense counsel has voiced diligence in preparing their case. However, the relatively recent appointment of lead counsel and even more recent appointment of co-counsel, in light of severity of crime and voluminous discovery, leaves the court to find continuing the trial will not result in impairment defense of case. That doesn't make sense. That would make a lot of sense if defendant was asking for an extension. That would make a lot of sense if defendant was asking for an extension. Hey, you know, I just recently got appointed to this case, relatively all things considered. And, you know, it's a death penalty case, so there's that. Plus, it's a cult murder thing. And also, my client is implicated in, you know, other states. One which has an indictment and one which is looking. So, you know, also the death penalty is on the line, so kind of complicated. This doesn't make sense to my mind, right? If the defense was asking for an extension and I had to find a reason to grant it, these would be pretty good reasons, right? I need more time to prepare. But defense says, well, I don't want more time to prepare. I mean, that's on the defense, right? That's on the defense. It's their rights. It's their speedy trial, right? If you invoke your rights, you know, that might be a negative to you, but they're your rights, for better or worse. And that's true for kind of all your rights. You have the right to do things or not. So this doesn't make sense. It's like, well, it's not prejudicial to the defense, but you know who disagrees with you? The defendant, who doesn't want it. Maybe they won't be prepared, but, you know, that's on them, perhaps. So, I don't know. Seems a little odd to me. Excuse me. On May the 2nd, 2022, the state filed notice of intent to seek the death penalty. This is an arguably complex preparation defense. Yeah, but they don't want more time. Of note, no argument has been advanced by the defense that delay would impair their ability to defend. Okay. On balance of factors weighs in favor of the state. That doesn't really make sense to me. I don't like this analysis. In weighing the factors, the court considers these factors weigh in favor of the state. In addition to these factors, the court must determine, pursuant to law, whether there's a substantial reason that rises to the level of legal excuse for delay. In this case, defendant is charged as a co-conspirator. The overt acts alleged in the indictment and current conspiracy have led this court to conclude defendant and Daybell should be tried together. That makes logical sense. The court is cognizant that the defendant is in custody and has been in custody for an extended period. While this factor weighs heavily and undue incarceration must be limited, it does not outweigh factors favoring finding of good cause. In summary, this is a death penalty case. That's a bad reason. That's a bad reason. The statute doesn't talk about death penalty or anything like that. That's a bad reason. The discovery volume is extraordinary. Defendant's defense team has only recently been fully assembled and has expressed concerns with the ability to be fully prepared. But they haven't asked for more time. That's kind of on them. This is on them, right? It's like, it's up to you. If you want to go into trial ill-prepared defense, the state is going to crush you. But, that's on you. It's your rights, on your head be it, as they say, right? So I don't know, man. Yeah, Q squared has a right. State wants to delay so defense will have more time to prepare, even though they don't want it. Heads I win, tails you lose. Kind of sort of Q squared. That's kind of where my legal budding is getting pushed. The trial itself has been set for a duration of 10 weeks, which for a death penalty case of this kind of complexity with occult murder, okay, yeah, further confirms the scope of the evidence the state intends to introduce. Yeah, but the defense doesn't want more time. The court is concerned defense may be impaired by requiring to commence the trial in October, when they're relatively recently appointed. But the defense doesn't want more time. On the other hand, the state has had far more time to prepare, nearly 3 years. But the defense doesn't want more time. Defendants have not advanced any argument delay sought will impair defense, but they don't want more time. Finally, the court has previously determined that the case should be tried together. Yeah, but they don't want more time. On the balance of these factors and full consideration of the record, it's determined the state has met its burden to extend by 6 months trial an additional 3 months. Note here, by the way, that we're just really citing the statute. Further, the court determines based on the same rationale, the constitutional rights are not violated. That's lame. I mean, on the statute, maybe, but on the constitutional analysis, why is it the exact same? Are you saying the statute and the constitutions, are you saying both the federal constitution and the state constitution and the statute are all concurrent with each other? So they're all one and the same? I guess that could be true, but your analysis kind of sucks. Your analysis kind of sucks, especially for a death penalty case. When, if this should come to pass someday, the defense will be looking for every possible reason to appeal. And, this looks like maybe one of them. I find this analysis wanting. How does it work if the defendant doesn't want to waste speedy trial, but there's a court-appointed lawyer? I believe, I'd have to double check, but I believe waiving speedy trial is one of those decisions that is in the defendant's control. I don't believe, although I could double check, I'm not sure, so don't quote me on this, but I believe that a lawyer cannot waive speedy trial without their client's consent, because it's a constitutional right. And so the lawyer can't waive it. So, I think that's true, but don't quote me on it. We had one super chat today, $5 from Q Square. State wants to delay, so defense will have more time to prepare, even though they didn't want it. Tens I win, tails you lose. Absolutely, for sure. And I think there was another super chat in there somewhere. Noli Berlard became a new member. $1.99 from Jaka Spelunk. You see HG's Tutor 24 videos. AH, a narcissist, take notes. She's something, man. She is something, for sure. So, we're definitely going to get more into the Daybell thing. We're going to produce some edited videos on the introduction to the case. We're going to go through the indictment and also the Arizona indictment and also an article discussing it to some degree. So we'll get into all that. €3 from Guy Petit. Thank you very much. As always, it's appreciated. Appeal will happen with this. Daybell's trial should be moved to October. They can't do that either because it prejudices Daybell. They can't do that either because they've already given Daybell a date, so his attorney is banking on that time. So they can't move Daybell to October. So the state put themselves in between a rock and a hard place. That's basically what happened. They shouldn't have allowed They shouldn't have allowed the one to waive without the other. They put themselves in this position. That's not my problem. You know? So I was like, well, that's not my issue. So at this point, I don't know what you do about it except sever the trials. Which, is a pain in the ass. But there's no constitutional reason that you can't sever the trials. Like, they should be tried together, but this would be a good cause to sever the trials, right? One defendant wants severed. They want mutually inconsistent things to the point that you need to sever the trials, which is a pain in the ass because now you have to have every witness twice and all the evidence twice, and twice the case and twice the expense and twice the everything and twice the hoopla. So it's a total pain in the ass. But there's nothing constitutional that's preventing you from doing that. So that's probably the easiest solution. But they don't want to do that because it's a major pain in the ass. But this analysis is leaving me wanting. So all that good stuff. All those good stuff. So we still need another 32 subscribers to hit 95,900. So let's see if we can get 32 more subscribers. Constitution is more important than a pain in the ass. I agree. Yeah. Let's see if we can get 32 more subscribers out of this stream before we sign off. We are going to do edited videos on Daybell, the indictments. And also we're going to do an indictment. We're going to do a video edited on the Chrisley indictments because I know people want me to go over that. And we're going to go over that again because I think the video got deleted. Q Squared has been a member for 26 months. Thank you very, very much for all that. What else should we talk about? Let's talk about Johnny Depp a little bit. Why not? Let's talk about the Johnny Depp case and the Johnny Depp verdict. Have I seen the LawTube compilations? I've seen some of them. Some of them are hilarious. Do I want our quick stories? Let's talk about Johnny Depp for a little bit. And talk about my thoughts on the whole thing. Now that that's over, I should probably make a separate video. Maybe I'll do that. Maybe I'll cut it up and make a separate video of it tomorrow. All right, so let's plan on that, so you guys get to see it, and we'll just pretend like I'm going to cut this up and make an edited video of it. Ooh. Well, my friends, we have finally reached the end of the Johnny Depp trial. A saga of 7 weeks in my former home of Fairfax, Virginia, in which Johnny Depp and Amber Heard have both somehow won their case. This has been a long, ongoing case and a slog, and the jury deliberated for about 2 days, all told. They argued they did a little bit of about a half day today. They did a couple hours on Thursday, and of course a full day yesterday, so about 2 days. And they came to a somewhat surprising conclusion. They found liability for defamation for Amber Heard for 3 statements, the only 3 statements that were at issue, in the articles that she published and republished. Okay. They award him $10 million in compensation plus $5 million in punitives. What the jury doesn't know, of course, is that the punitive damages by law can be no greater than $350,000. So therefore, what they award him is $10 million in compensation and $350,000 in punitives. So they award him $10.35 million by law, right? Now, a lot of people wonder why the jury isn't told about this cap on punitives. And from first principles, it makes total logical sense because the 2 kinds of damages serve totally different purposes. And the one shouldn't really logically influence the other. So there's really no reason to tell the jury about it because they shouldn't influence the other, right? Compensatory damages are to compensate. Punitive damages are to punish. So the entire purpose of compensatory damages is to make a person whole. How much damage have they received? This damage can be received in any kind of form. Damage can be absorbed. It can be from financial loss. It can be emotional pain, physical suffering, basically any way a person can be hurt. Deprived opportunities, just any way a person could be prejudiced in any way, right? loss of function, bodily injury, whatever, right? All these things. So the compensation damages are meant to assess how much was it, right? Because that's all a jury can do is award money at the end of the day. So maybe, as the case may be, depending on what case we're talking about, you lost an arm, or maybe you lost an eye, or whatever, you're permanently paralyzed or whatever, but all a jury can do is award money. So the nature of compensation damages is supposed to make you whole. It is supposed to be an amount that will exactly equal the harm that has actually befallen you. The idea, at least in principle, is, that you should be perfectly willing to trade one for the other, right? Because they're equal, right? They balance, the scales completely balance. Like whatever harm has befallen you in reputation damage or in lost job opportunities or in emotional pain or whatever, right? And the big pile of money are equal to you. So it's like one is just an equivalent for the other. So the jury says, okay, that's $10 million. Okay. So that's the only question they're trying to assess on compensation. In punitive, they're trying to determine, okay, you've been bad, so we want to punish you on top of that. So not we want to like make him more whole. We want to punish you as a warning to others, right? We don't think it's fair to merely give him what will make him whole. We want to give him some extra on top, as a punishment to you for you doing the bad thing. So this is the point of punitives. Now, Virginia, like many states, did their whole tort reform thing. And Virginia said that we're going to cap the damages at $350,000. Whether or not you think that's a good idea or a bad idea, the Virginia legislature is in control of its law and said, we're going to cap the damages. So the reason you don't tell the jury about the cap is that there's no reason for them to know, right? There's no reason to know that they're limited on how much they can punish them any more than there's a reason for them to know how much they're going to punish them in a criminal case. You don't tell them that either, right? It's like, do you find the guy guilty of bank robbery? You don't tell the jury how many years he might get for that. You don't tell them the range of possible sentences. You don't give them that information. You just ask them, is he guilty of the robbery? And whatever the legislature sets out as the damages, which in this case is prison time, is what's awarded, right? You don't have to give the jury that information. There's no reason for them to know. They just have to reach the factual assessment. Is he guilty of the crime, the robbery, or in this case, did he do the thing, and how much should we punish him? So the very reason that you don't tell them is because you don't want them shifting the damages over. Because the whole idea about people asking, like, hey, why didn't they tell the jury? Because if they had known, surely they would have just said, okay, we're going to give him $14 million in compensation and $315,000 in punitives. Well, that's the exact reason you don't tell them, because there's no reason to do that, because the jury's already determined implicitly that he only suffered $10 million worth of losses, right? That was the compensatory damages. That was their determination. They already made the determination that he didn't suffer $14 million. So if they could transfer money from one pile to the other pile, they would be doing something improper. They would be awarding money as compensation that isn't compensation, because if it were compensation, it would already be in the first pile, but it's not, right? So the very reason you don't tell them this is so that they don't corrupt their judgment. There's no reason for them to know. Just how much do you put in the compensation pile? How much do you put in the punitive pile? You can compensate him unlimitedly, because the question is, how much was he hurt? So that could be unlimited. And then they say, oh, by the way, the punitives are only $350,000. You don't tell them because there's no reason for them to know. So that's the philosophy behind it. Whether or not you agree with it, now I've explained it to you. Okay? That's the reason. They don't need to know, because the only questions they have to ask is, how much was he hurt? Give a number. Okay, how much do you want to punish him? Give a number. Those are two totally different questions, and there's no reason for them to know there's a cap on the one or the other, because if they did, they would move money from one pile to the other, and they would corrupt their judgment. They're not supposed to do that. They're supposed to make a judgment according to the law. They're supposed to make compensation damages compensation, and punitive damages punitive. And never the twain shall meet. So they don't need to know. That's the basis, right? Okay. So therefore, his award goes down to $10.35 million. Fine. Amber Heard, surprising everyone of the panel, surprising everyone, the panel won their counterclaims. Now, they won the most specific of the counterclaims. They won the one about the spilling of the wine and the police being called twice and blah, 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 blah. Right? They go through this fairly specific recitation. Now, there's a couple problems with this decision, in my humble opinion, in terms of the jury reaching the conclusions they did. The first problem, to my mind, is there's a principle in defamation law where if the pleaded truth creates the same impression as a defamatory statement, nobody cares. Right? If I defame you by giving a false statement of fact, but if I were to tell them the truth, it would create the same impression in the person I'm telling's mind, then like they might have bad information, but it made no material difference, right? It left the same exact impression to them. So what do we care? And so one of the ways I explain this is by saying, let's suppose there's a guy and a guy says, I say to a guy, hey, this guy has committed 5 murders. And he says, that's not true. I only committed 2. Right? So the statement I made is 5 murders. The truth apparently is 2 murders. Here's the question that you have to ask. If I said 5 murders, how would you feel about the guy? Okay, now I told you 2. Do you feel differently? Do you feel much different than you did before? Probably not. Probably don't feel that much differently than you did 5 seconds ago, right? It's like, oh, it's 5 murders. Ooh, I really hate him. Oh, no, it's only 2. Oh, okay, I don't hate him as much now. See, this is what we're talking about, right? It's absurd. It doesn't make any difference. There's no difference between the defamatory statement and the pleaded truth as it would be perceived in a person's mind, right? Nobody cares. It is a distinction without a difference, as they say. So one of the problems I have with the jury's conclusions is, sure, you can find lots of faults with the facts of what he said, based on the evidence that was presented, right? In court, there's no evidence of a second 911 call. Outside of court, there is, but not in court, so we don't care, right? So you can also say, oh, there's no evidence of the wine spill. There's no evidence of this. There's no evidence of that, right? But this is like where the details, to my mind at least, don't matter. Sometimes the details matter and sometimes they don't, right? And this is why, as lawyers, the answer to everything is it depends, because do the details matter? Well, it depends. Here's an example where, to my mind, the details don't matter, at least in my humble opinion, because there is, to my mind, not really much difference between like the pleaded truth and what the in terms of what the evidence shows. Like, so Amber Heard says a pleaded truth of like, it totally happened, it totally did. So we're going to ignore her pleaded truth because no, but we're going to like interpret the evidence charitably towards Amber Heard. I know that's hard, but bear with me for a second. We're going to interpret the evidence charitably, and we're going to say, okay, something did happen, but not exactly this, and we're going to decide how much we care about the difference between those two things. And I'm like, yeah, I don't care that much, because like what Waldman said versus like what the evidence seems to suggest, yes, as to the evidence in court, yes, there is differences, but the differences to my mind don't matter because they do not, to my mind, create a different impression in the mind of the person listening. So that's problem number 1. Problem number 2 is the actual malice, right? Knowledge of the principal, which is to say Johnny Depp, can be imputed on the agent. Anything the principal knows, the agent knows, because the principal is responsible for his agent, right? If the principal doesn't tell the agent something they need to know, that's on the principal, right? They're your agents, so tell them. So all your knowledge gets imputed down, but the reverse doesn't seem to be true under the operative law. So Johnny Depp, I don't think, knows that it's false. Johnny Depp, I don't think, is recklessly disregarding. Johnny Depp is being held accountable for Waldman's statements, which fair enough as far as agency goes. But it's not like Johnny Depp recklessly disregarded. And to the extent that anyone was paying attention, Waldman, by his own testimony, went through all this stuff to form his opinion. He went through, I mean, we heard him testify and we saw lots of evidence. He seemed to consider a lot of different things. So maybe he drew the wrong conclusions in the end. You know, so maybe his statements were false, but, you know, they weren't made maliciously because they weren't made with reckless disregard. Waldman certainly doesn't know because he wasn't there. So Waldman can't know. Neither can Johnny Depp. He wasn't there. So neither of them can know. Waldman isn't recklessly disregarding. So even if he's wrong and it matters, it's still not reckless disregard. So first of all, there's no damages because it doesn't matter. Second of all, if it does matter, he didn't recklessly disregard, which kills the actual malice element. And then third, on top of it all, is the whole agency theory I'm not sure really works for matters of law, right? The idea that an attorney is the agent of the clients would make sense, except for the fact that under the relevant law in Virginia, only an employee can be an agent, not an independent contractor. Only an employee can be an agent, not an independent contractor in Virginia. So Waldman might be working at the behest of his client. He might be following his client's directions. He might be being paid by Johnny Depp, but he's not Johnny Depp's employee. And there seems to be case law that says exactly this with respect to attorneys in particular, that they're not employees. So like, it's not even like generally speaking, there's case law that seems to say that for attorneys in particular, they're not employees. Now the judge and the trial court seem to be working under the conclusion that this guy, Waldman, was working for Johnny Depp for a number of years. And not just on one matter, but a whole number of matters. A whole number of cases for a series of years. Okay. And this somehow, basically, according to the judge, somehow transforms him from independent contractor status to employee status. I'm not sure the law supports this proposition. A lawyer hired once is an independent contractor. I'm not sure a lawyer hired over a period of time, or even on what we call a classic retainer, which isn't used very often, because lawyers can be hired under a whole bunch of arrangements, right? So there's something called a classic retainer, which I don't know that any attorney uses anymore, but it's because it's really old school. A classic retainer is where a client gives an attorney money just so that they're their attorney, right? So it would be basically, I'm your attorney for hire, whether you use me or not, right? So basically, I'm your attorney for the year on whatever cases come up. So you're kind of like hiring me kind of for the year, kind of sort of, right? But if you don't use me, whether you use me or not, I get to keep all your money, right? That's a classic retainer. It's very, very old school. Attorneys don't really do this anymore. But even under like the classic retainer where it's like, okay, I'm going to give you $100,000. You're my attorney for the next year, whether I use you or not. I don't think the case law supports that he's a employee, even though he's in this status. I still think he's an independent contractor, even if that goes on for a number of years. So even if we're doing some really old school shit here with an old school classic retainer, which I don't know is true because like basically no one uses them anymore. But even if we were, I still don't think he's an employee. So we got a problem there on the agency theory. So I've got a couple problems with the verdict on those levels. I disagree that the statements are different enough to matter. I disagree that he had actual malice. And I disagree that he was acting as an agent within the meaning of the relevant law. So that would give 3 different grounds for Johnny Depp to appeal, incidentally, that I just told you just now. Regardless of whether he can appeal successfully or not, for the moment, the jury has awarded a verdict of $2 million in compensation and 0 in punitive. So that means that Johnny Depp now has a net award to him of $8.35 million. Now, Virginia doesn't formally do offsets, which is kind of stupid because what's the point? Because I could give you money and just be like, well, now you have the money, I want it back. But, you know, whatever. So whether or not they'll work that out or not, who can say in terms of that? But the net, one way or another, is Johnny Depp with $8.35 million. Now, Amber Heard has promised to appeal, which should surprise absolutely nobody. Does she have very good grounds of appeal? Well, I think she might be able to win on the second or third statement. I don't think it's necessarily a given by any stretch. But the third statement in particular, I think, is literally true. The defamatory implication, for my mind, is a little hard to find. So maybe it's unsupportable as a proposition at law. Possible. On the second one, same idea. More unlikely to my idea, but possible. But I'm not really sure how she gets past the first statement. Because with the sexual violence in the HUD line, she did republish it. She added words. She formally adopted it. She did it in the most blatant language possible. Today I publish. So she is adopting that language officially. She argued that when she was talking about sexual violence, she was talking about things other than Johnny Depp. But that's a question of fact for the jury. So even if she was a victim of sexual violence in some other context or by someone else, the question is, when she said that, was she talking about that or was she talking about Johnny Depp? And that's just a question of fact for the jury. And there's enough evidence for the jury to go either way. So I'm not sure there's anything for the Court of Appeals to do here. So even if the Court of Appeals overturns Johnny Depp on either Statement 2 and or Statement 3, I don't think they overturn on Statement 1, because I don't think that makes much sense. So Amber Heard might win part of her appeal, but I don't see them winning all of it. And the only other thing you could try to do other than that is you try to find some error in the court proceedings. You could try to argue the errors where Elaine got objected to every single time when he was trying to do cross-examination of or redirect of Amber Heard, because she got shut down no matter how she tried to do it. So you could try to argue like abuse of discretion there, but I don't think it works. You could try to argue like the attorney made an improper argument or something, but I don't think it works. So I'm having a hard time right now seeing any sort of, clear error or abuse of discretion. Because even if you find clear error or abuse of discretion, clear error for legal mistakes, abuse of discretion for factual mistakes, even if you find abuse of discretion or clear error by the judge, which is hard enough as it is, you then have to go to the second part of does it matter? So then the Court of Appeals gets to play omniscient over there, and they get to say, okay, I'm a smart Court of Appeals. The judge made a mistake here. Let's assume that mistake didn't happen. Does the jury still come out the same? Right? And the answer almost inevitably there is, of course, yes. Because whatever mistake might have occurred in law or fact is probably not substantial, either in individuality or in collection, to be enough to overcome all the things you need to overcome. So it seems Amber Heard's options on appeal don't seem immediately obvious. As appeal briefs get written and as the arguments get written, I absolutely will cover them, of course, and we'll cover them. Johnny Depp's arguments on appeal seem much more promising for the reasons I stated. It's like, I think that Johnny Depp's ideas on appeal seem better. Again, I'm not saying by any means he'll win, because as they say, appeals are for losers. But Johnny Depp, to my mind, has better ideas that are more workable on appeal. So we'll see. We'll see. And then going past all that, of course, is the other idea of collecting damages, because Amber Heard doesn't have $8.35 million. Her net worth is calculated at roughly $2 million, which, there are streamers who make more than that, on an annual basis, or even better than that, on Twitch, who make better than that. Mr. Beast, I think, makes something like, what is it like? He makes a couple $1 million a month. So Amber Heard is doing so well in the financials, her salary is less than like 2 weeks salary for Mr. Beast or something. So says something about our modern economy or something like that. So she doesn't have it. Rob from Law and Lumber on his channel tonight was doing an analysis on the bankruptcy issues. I would direct you to his attention on that issue because he's more knowledgeable on bankruptcy law than me, and anything I say contrary, you should defer to him because bankruptcy is not one of my stronger areas. My understanding is that this cannot be discharged in bankruptcy because of the willfulness and maliciousness nature of it, but again, defer to him. But even if they can't defer it in bankruptcy, filing for bankruptcy defers time. And so, like, I imagine this will be fought over for a while. If I'm Johnny Depp, what I probably do at this point, with my $8.35 million, what I probably do is I probably divide it up 8 different ways. And I probably say to 8 different collection agencies, I find the 8 meanest collection agencies I can find, right? And give them each, you know, $1.05 million or whatever it is, and say, you know, hey, this is yours now. Give me 5 cents on the dollar, and have the, you know, 8 meanest collection agencies hound her to the end of time because that sounds hilarious. So, but we'll see about all that. Of course, they could reach some other settlement. Just because they have damages doesn't preclude them from reaching a settlement. So they could reach some agreement even now. Again, I have no idea what that would be. I wouldn't begin, if I were Johnny Depp, I would not even begin to contemplate any kind of settlement without an admission, which you will never get from Amber Heard. I'm willing to do a lot. I mean, if I were him, which I'm totally not on every possible level. But I would sooner negotiate down to $1 than I would not require her to give an open, full admission, right? I'll negotiate all the way down to $1, but I'm not going to give up that. And she won't do it. I don't think she's capable of doing it. So, like, I don't know what, if anything, they can do, you know? I don't know if anything they can do. She can't give admission, she'll be arrested. I think that's doubtful. I mean, I understand what you're saying about the perjury issues, but I don't think it's doubtful. And if we're really, really that concerned about it, we can probably get the prosecutor to give her immunity for it. Because, like, you know, perjury is not their highest priority, specifically in a civil context. So if we're that concerned about it, we can probably get an immunity agreement on top of it from the prosecutor. So I'm not that worried about it in terms of that being a problem. So, you know, yeah. So all that good stuff. So Nick is starting in 5 minutes. Let me text Nick and see if he wants me on, because I think I would like to go into a stream, and I'd like to do a little bit of drinking celebration with Nick. That sounds like fun. So let me take Nick real fast. Okay, and see. No, I can type. V. There we go. Damn. Okay. I'll text him, see if he texts me back. You know, text me back. I'll go on for a little while and we'll hang out with him. That could be fun. You know, that can be fun for a little bit. He's starting in 20 minutes, so that's fine too. Yeah. The ice cream pick with JD passed out is every collegiate shame pick. I know, right? Really? Yeah, absolutely. For sure. Okay, and he says, yeah, sounds good. Excellent. So it looks like I'm going to be on with him. Cool. So I'll just wait for him to give me the link, and I'll pop on him with her for a little bit. I found this really nice bourbon. It was very cheap, made out in San Antonio. And so I'll open that and drink some of that with him. That'd be cool. He's scheduled in 8 minutes. He starts in 20 to 30. Sounds about right. Yeah, sounds about right. Well, can I get another 21 of you to subscribe? Another 20 of you to subscribe before I hang over to Nick's? Can I get to 95.9? I am not beyond begging. Can I get 20 more of you to hit the subscribe button, please? If the subscribe button is red, please hit the subscribe button. It wants to be gray, and you need to be the change we need to see in the world. Let's see if we can get over to 95.9 before we head over. I'm not asking anyone to dupe accounts. I'm not asking anyone to dupe accounts. I'm definitely not asking anyone to do subscribe bots. Can't hit subscribe anymore. I know. I appreciate all the people who are the uncivilians. Appreciate the people who've hit that join button. I really do value each and every one of you who helps to subscribe to the channel. You got your Scales of Justice, King? You look good with them, too. You look good with the Scales of Justice. If you want Scales of Justice, hit the join button. That's how you get to be an uncivilian and get your name on stream. Matt, you could subscribe too, Matt. You could hit that join button. Get a Scales of Justice by your name, Matt. Just saying. Oh, there's a bourbon I just got from San Antonio. I'm not sure what it's called, but I'll drink it on his stream, and it was really good. It was very inexpensive. I wanted the scales as a tattoo at one point. You could do worse. You could definitely do worse. Thank you for all the people hitting the subscribe button. Appreciate all those subscribes coming in. Let's see if this count is off. Should be close, but let's see. No, I think that's the right count. 880. Whistle Pig is not my favorite. My boy in Air Force Basic in San Antonio. Shout out to Noah. Hello. Tennessee Butterscotch Whiskey. We own it for forever? Absolutely, yeah. You're more substantive than L&L? Thank you. That's very kind of you. Listening to this while planning my next school year. Pretty sure it's going to make me smarter. That's awesome. I'm glad I'm doing that, Beverly. That's very, very cool. All right, I'm going to sign off for now so I can go jump on with Nick, get a little break in between or something. Please remember to do all the YouTubey things. It's been a whole bunch of fun. Until later, my friends, I hope all is well. Cheers and good night.